Good afternoon, everyone, and welcome to today's webinar, Effective Progressive Discipline and Performance Management, Strategies for Addressing Poor Work Performance, Behavior, and Misconduct. My name is Matt Link, and I'm a partner in Fasken's Labor, Employment, and Human Rights Group here in Toronto. And I'm so pleased and thrilled to be joined by my colleagues in the LEHR group, Gillian and Alex Ognibene. Before we begin this presentation, because we have a lot to get through, just a few housekeeping notes. First of all, there's an online survey that you'll be able to access at the end of this webinar. Please click on the survey button underneath the video. We really do appreciate you completing these. They help us determine future topics, and your input, as always, is greatly appreciated. In terms of the materials that you'll be seeing today, if you'd like to access them in the future, they can be accessed via the Materials tab at the bottom of the screen. And we're also recording today's webinar, and both the recording and the materials will be emailed to you post-event at the address that you registered from. In terms of questions, we've received a lot of questions on this subject in advance of the seminar, so we'll try and get to some of those. And in addition to that, if you have questions that come up during the webinar itself, please feel free to put a question into the chat box. Again, we'll do our best to answer as many as we can in the limited time that we have available. Technical support. If you have technical issues during the webinar, please click the Tech FAQs and the Tech Support chat buttons, and one of our friendly and helpful techs will do their best to assist you. This presentation and many of the others that we've had over the last year and a half, in part, touch on the subject of COVID-19 and its impact on the workplace. If you're looking for COVID-19 specific information, we really do have a wealth of information and resources available in our COVID-19 Knowledge Center, which you can access at Fasken.com. And then finally, before we get started, I can confirm that our next webinar will be held on May the 26th at 2 p.m. Eastern. And the subject of that will be effective workplace investigations, social justice, and cancel culture. And again, to register for the event, just head over to the Fasken.com website, the Fasken Institute section, in order to not only register for that event, but also for any upcoming events. And with that, I'm pleased to get today's webinar underway. You'll see we have a packed agenda. And again, amongst the things that we're going to hopefully cover with you today is starting off with the purpose and importance of progressive discipline. We'll look at some conduct that may warrant progressive discipline, examine when and how, as an employer, to implement progressive discipline. We'll also look at situations and cases where progressive discipline may not be warranted, whether it's no discipline at all or it's conduct, for example, that might be deemed so serious to proceed immediately to termination. We'll then pivot a little and look at performance management and performance improvement plans. And certainly I know we get questions sometimes, are PIPs sort of a thing of the past? Are they still useful? Are they useful as part of the progressive discipline process? And our answer to all of those are yes. Second last, we'll look at some non-disciplinary strategies for addressing poor performance, and then round the webinar out by looking at other considerations to keep in mind when you're taking disciplinary action. And that includes human rights, accommodation, and other considerations. So, starting off with the purpose and importance of progressive discipline. I guess these 2 bullet points basically say it in a nutshell. It's a process by which an employer imposes disciplinary measures of increasing severity to correct employee misconduct. And that last part is important there, is that the primary purpose of progressive discipline should be to correct employee conduct. And the hope there is that there's no discipline that will be necessary in the future. Secondly, it acts as a performance management motivation tool, again, to motivate employees to correct their behavioral and conduct issues, and to hopefully ensure that they won't occur in the future. Moving on again to talk about the purpose and the importance of progressive discipline, I think it's important to sort of address the elephant in the room, which is that many managers and supervisors do not like issuing discipline to their employees. They prefer not to have the difficult conversations that sometimes need to take place with employees when you're issuing discipline. And some employees also are not open to constructive criticism, and particularly when you have an employment relationship that has gone well for years and years and has been discipline-free, but something comes up and you need to then address it. That can be jarring, and it can sour the employment relationship. And of course, again, managers would prefer to avoid doing that, as long as continued employment is preferable to termination. And then if then they want the employee out, well, then it's a rush to terminate. All that being said, there's many reasons why progressive discipline and a cogent, clear, effective discipline policy and program is critically important for you as an employer. And here are just some of the points on the screen and in front of you right now that are supportive of that. First of all, progressive discipline provides fairness for both the employee and the company. The individual gets an opportunity to understand, for example, that what they've done is wrong and needs to be corrected, and gets opportunities to improve. At the same time, the company is able to institute a program of ever-escalating discipline, which, if it's not corrected, may ultimately result in the termination of employment down the road. Progressive discipline is a tool to improve employee performance and change negative behavior. It can be used by the employer to reinforce your expectations, as well as existing policies and work rules. It gives employees an opportunity, if they're struggling with certain issues, to be supported or to have access to management support. From the legal side of things, it helps employers avoid potential legal claims, or if not avoid them, to be able to put forward the best defense against whether it's in the non-unionized environment, a termination for cause, or in the unionized environment, some form of discipline up to and including a discharge. It allows you to create a written record. And as sort of your legal counsel may have told you, in situations ultimately where you're dealing with a piece of litigation that involves a history of discipline, having a written record, and particularly a contemporaneously created one at the time, is invaluable for you, both in terms of defending against a claim and to put forward your position as to why the decision to discipline and or terminate or discharge is a reasonable one. It's also important because employees won't be able to say, or certainly they shouldn't be able to say, I had no idea this was coming. I had no idea that this behavior or this conduct was a problem. That's going to be difficult to say when there's a series of progressive discipline on their record, each one of which has been reviewed with them. And then finally, it gives you as the employer the opportunity to fix things with employees and hopefully to avoid going down the road to termination and all the potential costs associated with that, not only with respect to ending the employment relationship, but also onboarding new employees. So moving on then to the stages of progressive discipline. And again, these can vary, but just a sort of a general outline, starting with verbal warning, written notice, suspensions without pay. And you'll see we've put a question mark there, union context only. I'll quickly talk about the potential for a claim of constructive dismissal in the event of a suspension without pay in the non-unionized setting, and then termination of employment. Just very quickly for those unionized employers, with respect to your employees that are covered by a collective agreement, it is always important, no matter how many times you've reviewed the collective agreement, when you're preparing to apply progressive discipline to a unionized employee, to check the collective agreement and see if it says anything about either discipline, and specifically the stages of progressive discipline, which some collective agreements do mandate expressly, or secondly, the obligation on the part of the employer to allow representation in the form of a union steward to be present when progressive discipline is being applied. And then last but not least, often because it is sort of sometimes hidden and tucked away in the corner of the collective agreement, make sure to check to see if whether there is a sunset clause on discipline on file. And that largely in the unionized setting applies to progressive discipline. Sunset clause is a provision that that states that after a certain period of time, in most instances somewhere between 12 and 24 months, the existing discipline on record is wiped from that record, and you're essentially starting at zero. And so for those of you applying progressive discipline, that essentially means you're back to the start. So in terms of the stages of progressive discipline, starting off with verbal warning, for many employers prior to this, they may issue a letter of counseling or a note of counseling. That's generally not viewed as being disciplinary, but that's often the first step to then get you to a verbal warning. And it's called a verbal warning, but it's important to actually document that you've provided the verbal warning. It can be as simple as a note to file, confirming that you've had a conversation with the employee, you've set out the problem, you've set out your expectation, you've given an opportunity to the employee to explain themselves, and then you've advised them as to what the consequences are for failure to correct their action and for future conduct of a similar fashion, that it can lead to further discipline up to and including termination of employment. The second stage in progressive discipline generally is a written notice or written warning. And this is issued after the verbal warning if there has been really no change in the employee's behavior, and let's say, for example, that the conduct or similar conduct has occurred again. Again, you're wanting to meet with the employee, give them an opportunity to explain what happened. Again, if it's a unionized setting, they may require representation, and you'll want to have the written warning ready and available to provide to the employee at that time. It's important, certainly as we get to the written warning stage, to begin to use more forceful language in your progressive discipline that sets out the very serious consequences of further performance, conduct, behavioral issues. And that means not using words like may or might result in further disciplinary action. You'll want to make clear the consequences so that the employee can't be surprised. You want to state in writing that the company won't tolerate the behavior or the conduct that's occurred, and that further occurrences will lead to further disciplinary action, including a suspension without pay, up to and including termination of employment. Next step then after written warning generally is one or more escalating in length suspensions without pay. Depending on the employer, it can run anywhere from a 1 day, 3 day, 5 day to 10 day unpaid suspension. It can be less than that. And again, it's going to depend on your workplace. Again, what works for you and your own individual practices. So there's no set requirement as to X number of suspensions before you move on to termination of employment. What is critically important, again, as with written warning, is with the notice of suspension without pay, is to continue to emphasize the serious consequences of failure to correct the person's behavior. And as in the written warning, you want to indicate that further conduct will result in further disciplinary action. With suspensions without pay, particularly as you're landing on the penultimate suspension, that for most employers, that'll be a 5 day or a 10 day suspension. You want to make it absolutely clear. Not that with respect to further incidents of misconduct, that termination may occur. You want to clearly state that it will occur. So there can be no claim of misunderstanding or uncertainty as to what the next consequence will be for misconduct, and that being termination of employment. We've got there a note, as I'd indicated earlier, union context only. And that really refers to the fact that suspensions without pay leading to termination for cause are, again, boilerplate within the unionized workplace, but are not as common in non-unionized workplaces, particularly in sort of white-collar professional situations. And depending on the length of the unpaid suspension, you need to be aware that there is a risk that unless your employment agreement with your employee provides you as the employer, as part of your disciplinary process, to issue suspensions without pay, it could give rise to a constructive dismissal claim. It's unlikely that a 1 day or a 3 day or even a 5 day that'll happen, but a 10 day or something longer than that, be wary that could give rise to a constructive dismissal claim. Finally, we move on to termination of employment. Again, I'll say this a number of times. The content of the termination letter is critically important because in many cases, it's going to be the central document that's going to be relied on in litigation, whether it's in the unionized context, in an arbitration, or in an unjust dismissal claim, or in a wrongful dismissal claim. If it's a termination for cause, you'll want to list in detail the reasons for why the employment is terminated for cause. A simple, because you're terminated for cause because you violated the employer's code of business conduct is not going to cut it. Particularly, for example, if you're a federally regulated employer, the Canada Labor Code is quite clear that the reasons for termination must be included in the termination letter, and you can't go back afterwards and add into it. That's what the adjudicator looks at. So provide detail as to the reasons why you're terminating for cause. Particularly, again, what you're going to want to do in our current COVID world. Meetings in person can be difficult, but at least it should be a virtual meeting if you can't meet in person. Over the camera, you're going to want to provide the employee with the letter, give them an opportunity to review it, give them an opportunity to say anything that they want to say about that, and then move forward. Next, we'll talk a little bit about conduct warranting progressive discipline. Again, I think it probably goes without saying, hopefully, that the onus of proof in discipline cases is on the employer. So you as the employer need to establish that the actions of the employee warrant discipline. Now, fortunately, in most situations, it's a civil standard. It's a balance of probabilities. Is it more likely or not that this occurred? The exception to that is where the conduct, the behavior, the misconduct is closer to what could constitute criminal activity. And thinking specifically of situations involving theft, fraud, misappropriation of intellectual property. There, the standard of proof is higher, and it's the clear and convincing evidence standard. Now, hopefully, doesn't matter whether it's quasi-criminal or not. Hopefully, in terms of when you are putting together a case for discipline of any nature, it's gonna meet that clear and convincing standard. You shouldn't just leave it for the quasi-criminal situation. Hopefully, you're not going to have to be placed in a situation where, okay, it's a judgment call as to whether the person should be disciplined or not. In terms of what the adjudicator will ask, we go over to the next slide. As it relates to discipline and the imposition of discipline, the first question I'll ask is, do the facts warrant the imposition of discipline? It's a yes or a no. And then secondly, if yes, is the specific penalty imposed just in all circumstances? And how do we determine whether the penalty is just or not? Well, we move on to the next slide, and we look at the host of aggravating and mitigating factors that you as the employer will need to balance in terms of determining whether or not the discipline that you've imposed is just or appropriate or not. Factors mitigating against discipline on the left side there are lax supervision or inconsistent past disciplinary practices. The violation is not a critical one. The employee has a clean disciplinary history. The violation was not premeditated. The employee admits guilt, apologizes, expresses remorse. That's important. And also if the employee sort of acts in good faith and fully and freely participates in any investigation. On the other side of the ledger, an aggravating factors, leaning towards warranting discipline, are if, again, you have engaged in a strict policy in the past of issuing discipline, and this follows within that. If the violation engaging is critical to the business, the individual has a lengthy disciplinary history, violation is premeditated, the absence of an admission, remorse, or apology. And then if the employee is either deceptive or non-transparent during the investigation. You'll see in the middle is seniority, which can be both an aggravating and a mitigating factor. In some situations, certainly particularly in the unionized context, seniority is often a mitigating factor. In a non-unionized context, seniority can be an aggravating factor, particularly when it comes to behavior-related issues. You expect more of your senior, longer service employees. So moving on to the next slide, just a couple of quick case studies for you to start things off before I turn them over to Alex to talk a little bit about when and how to implement progressive discipline. We've got 3 quick fact patterns here where you can consider which disciplinary step is appropriate for the particular situation. And there is no necessarily right answer here. It's just meant to sort of get you thinking. So number 1, Larry misses a day of work and doesn't call to explain why. Now, there's a lot of facts that we don't know about for the time being, as is there a call-in policy? Does he have a history? But just on its face, in the abstract, this is a problem that could and should be rectified with a simple coaching session, letting Larry know the importance of calling in when he needs to take a sick day. After that, there should be no excuses going forward, and you'd begin the process then of progressive discipline on either the verbal warning or written warning stage. Number 2, Greg corners Martha in the hallway and purposefully brushes against her inappropriately. In this case, Greg has committed a serious offense of sexual harassment, and it's arguably premeditated as well. Depending on his prior, his work and disciplinary history, if he's engaged in this kind of conduct in the past, it may possibly give rise to a basis for termination. But in the abstract, again, without knowing more about the history, it's likely something that certainly warrants, at a minimum, a written warning and possibly a suspension as well. Again, making clear the seriousness of the conduct, the fact that repeated actions will not be tolerated, and that termination will occur if it happens again. And then filing number 3, Lucinda makes the same reporting error 3 times. She's already been coached on them. And again, this is, you've done your coaching here. How many more times should you coach before you implement progressive discipline? It doesn't seem to be working. And so a formal written warning with the consequences of failure to improve in the future is likely appropriate in order to try and ensure that that behavior does change. And given that Lucinda then is made fully aware of the consequences of failing to do so. And with that, I'll turn it over to Alex, who will talk a little bit about when and how to implement progressive discipline.
Good afternoon, everyone. Thanks, Matt, for that overview of progressive discipline. What's often overlooked in discussion of discipline is what groundwork needs to be laid as an antecedent to any discipline, and that involves the promulgation of workplace rules and standards of conduct. Some standards of conduct are so obvious that they don't always need to be stated in a policy. For example, don't steal. But often based on the nature of a particular position or industry or type of work, there will be particular rules that are particular to that job and that should be stated in workplace policies or handbooks. So that's obviously an important factor, is giving notice to employees that the rule exists. Employees should not be disciplined on the basis of rules that they don't understand or that have not been communicated to them. A second element of laying the groundwork, though, is ensuring that the rules are actually reasonable. Employers have the discretion in this regard to set reasonable managerial rules, but there should always be a rational connection between the rule and some legitimate objective that is served by that rule. Ultimately, where progressive discipline and termination sometimes goes wrong and is not upheld is where there is not a rational connection, or where workplace rules impose overly onerous requirements on employees that are not reasonably necessary. So it's important to keep in mind that ultimately you may be required to justify the rules, as well as the fact that they were communicated to employees and that employees were trained and supervised in order to ensure that they understood and could meet the rules. Sometimes these rules will be reduced to policies that can cover a range of topics. So for example, many employers, as discussed on the next slide, have attendance policies, which may set out standards for attendance and in what circumstances employees need to call in. In safety-sensitive workplaces, there may be special rules like lockout, tagout that tell employees how to properly perform certain safety procedures. Other types of employees may be subject to conflict of interest rules and specialized administrative procedures and policies. Those are cases where those specific policies will be helpful in setting out the rules, because they may not be obvious to an onlooker in terms of what would amount to just cause in those particular circumstances. Apart from those specific policies setting out standards of conduct, employers can also have a progressive discipline policy. And that policy would effectively set out what the consequences of breaching a policy or standard of conduct will be, and provide supervisors and managers with some guidance on how to carry out the disciplinary process. It's not necessary in every case to have a progressive discipline policy, and there may actually be different points of view on whether this is the best way of proceeding, because discipline does not depend on having a policy, and in some cases, having a progressive discipline policy can constrain or fetter discretion if it's not properly drafted. So it is important to seek advice when implementing such a policy, but generally we can discuss some of the features of these policies. Firstly, they should be rehabilitative in nature, so that they provide warnings and an opportunity to correct behavior, which allows employees to meet the standards that are expected of them. They should also obviously be progressive in that they move or escalate from less serious forms of discipline, like a warning, to more serious forms of discipline, like the termination of employment. As I mentioned at the outset of this slide, they should be flexible, and that means that progressive discipline policies should use permissive rather than mandatory language. So may lead to termination, or the employer may impose a certain form of discipline rather than will, shall, or must. The reason for using a more permissive kind of word is to allow some room for discretion and latitude in dealing with specific incidents of misconduct, and avoiding potential arguments by the employee involved that this policy was an followed to a T. They should also preserve the ability to dismiss for just cause upon the occurrence of a single incident of serious misconduct. Again, this is just to state that although progressive discipline is the overall approach, that does not mean that there will not be circumstances where the most severe type of discipline, loss of employment, would be appropriate on a first instance. Lastly, progressive discipline policies should summarize the process by which an employer will investigate misconduct leading to disciplinary decisions. And that duty to investigate is what we'll discuss in the next slides. So when you've detected potential misconduct in the workplace, what next? It's important to conduct a proper investigation to ensure that you have all of the facts and that you've given the employee concerned an opportunity to be heard and to present their version of what happened. Investigations should be timely and impartial, and it involves reviewing evidence and interviewing the employee and relevant witnesses to understand what happened. And can we prove it? Mindful that discipline requires proof of the discipline, and also its extent is relevant to assessing the severity of discipline that should be imposed. But as an absolute first step, it must be determined that the misconduct actually occurred. And that calls for an investigation. Matt discussed some mitigating and aggravating factors. Another reason to investigate is because often an employee who is trying to cover up misconduct will lie in the course of an investigation. They'll be dishonest or commit other misconduct in the course of an investigation, which can then further justify the discipline. So it can help in that regard, but it can also conversely produce mitigating factors like an apology or an admission on the part of the employee that might suggest that the employment relationship can be salvaged and that maybe termination or a severe type of discipline isn't the best way to proceed in that case. Acting in a hurry, on suspicion, or out of emotion can all risk compromising the disciplinary process. How can they do that? It could be through missing information, failing to identify a potential human rights issue that relates to the misconduct, not giving appropriate consideration to alternative or non-disciplinary measures. And it could even raise the inference that the employer did not believe that cause existed, for example, where there has been a delay in investigating, or that a particular employee was targeted, for example, where discipline is not reasonably consistent between employees. So for all of these reasons, it's important to investigate and understand the situation and get the employee's point of view before making a quick decision. This case demonstrates some of the failures that can occur when an investigation is not conducted as is required. In this case, a health and safety manager with 23 years of service, who was 70 years old, was terminated for altering spreadsheets and deleting emails. He had been given working notice of termination for a full year, and he submitted a sick note. And then while he was sick on leave, he deleted the emails. When he was confronted, he admitted that he had done so, but the employer did not conduct any investigation to ascertain the extent of the harm that was caused. The extent of the harm was quite relevant, or should have been quite relevant, to assessing whether it was appropriate to terminate a 70-year-old employee with 23 years of service. So ultimately, the British Columbia Superior Court in this case said that termination was not the appropriate recourse. The court said that the employer did have cause, but that had it investigated, it would have realized that a lesser penalty was appropriate in this case. This chart here shows a simple step-by-step of how to respond to misconduct. So from the point that misconduct is observed or there's an incident in the workplace, it's helpful to come up with a plan first. So a plan for conducting the investigation, a plan for the questions that you will ask for, of the employee, when you will ask them, what evidence should be reviewed, leading to a decision with documentation along the way. Next slide, please. So as Matt said as well, in relation to termination letters, documents are very important. Not only do they set out the reasons, but they will ultimately be the evidence that the employer will seek to rely on to justify its case of just cause in any hearing. So the documents that are relevant could consist of any type of document that's relevant to the misconduct, and that might be medical files, time cards, policy acknowledgements, and so forth. Other means of investigation could involve a search of the physical premises, a review of criminal records, drug and alcohol tests post-incident in safety-sensitive workplaces, review of any video camera or surveillance, and even a review of social media and text messages. So there's a number of ways, and the investigation should be properly calibrated based on the misconduct as well as any relevant interests such as employee privacy. This slide is another helpful flowchart that sets out how to explain misconduct to an employee. So it starts with determining whether and what level of discipline should be imposed after the investigation. As I've mentioned previously, this requires first establishing that the disciplinary misconduct occurred in fact, and what the extent of it was. The next step will involve communicating the employer's position to the employee. And lastly, defending the employer's position in adjudication if it gets to that step. And this is where a court will be looking to see whether the discipline that was imposed was just and proportionate in all of the circumstances based on the misconduct and any mitigating or aggravating factors. Discipline should be corrective rather than punitive. At a minimum, progressive discipline should advise the employee of the specifics of their misconduct, what is needed to improve, provide the opportunity to improve and meet expectations where the employment relationship is continuing, offering assistance, and warning of specific consequences of continued poor performance or misconduct. So this is a case where progressive discipline was upheld by a court based on the facts of the case. The employee in this case was known to have used his personal cell phone to take photos of female customers, and he had received warnings from the past from the employer that this was inappropriate and that future occurrences of this could lead to disciplinary action up to and including termination. Then in August 2018, the same employee took a photograph and 2 videos of a client in the dealership without her knowledge. And he did so on a computer or a tablet that was provided by the employer. The discipline was ultimately upheld in this case, largely because of the fact that the employee had been warned in the past, and also that this kind of misconduct that was involved struck right at the core of the employment relationship, in that it involved customers, and customers whom it was not reasonable to assume had consented to this kind of photography. Next slide. How to communicate effectively when issuing discipline. This can be a tricky subject. There's mixed views on whether the sandwich approach is the best way to proceed. Some say that it sugarcoats the situation and often ends up with the positive feedback being overwhelmed by the negative at the end of the day. So in that regard, maybe sometimes it's best to just be clear and cut right to the point. The hallmarks of an effective disciplinary letter, in contrast, are to clearly spell out the problem, define the solution and expectations that you're looking for, describe the impact of the misconduct at hand and of future problems, and offer assistance to get to where you want the employee to be. As Matt said, vague references are not good enough. Remember that this could be a disciplinary letter or any kind of reprimand could be evidence in the future. It will be relied on as the reasons for termination. So vague references to what happened will not suffice, and nor can discipline that has not been documented or communicated to the employee be relied upon. So clear communication and document management is an important step of this process. Generally, employers will be held to the reasons for discipline that are advanced at the time that discipline is imposed. New facts may be admissible in some cases pursuant to the doctrine of after acquired cause, but this is very much the exception rather than the rule. Part of this duty to investigate and the procedural fairness aspect is that a decision should not be made until all relevant evidence has been gathered. And when new facts and evidence come out after a decision has already been made, even if the law allows that and it is legitimate, it can definitely raise the implicit inference that maybe the employer is padding its case, or that it could have conducted itself differently, or maybe conducted itself for an ulterior purpose in the first instance. So these issues of timing and investigation are important, and employers are often held to the reasons that are initially provided rather than continuing to supplement those reasons after a decision has been made. Document, document, document. I think we've covered this, so next slide, please.
Hi, everyone. So as Matt said at the beginning of the presentation, there may be situations where progressive discipline is not warranted. And that could either be because the situation is not serious enough to warrant progressive discipline, or because the situation is so serious as to warrant immediate dismissal. So situations where progressive discipline may not be warranted include serious misconduct that has the effect of permanently breaking the trust between an employee and an employer. So that can include situations such as serious safety violations in safety-sensitive workplaces, assault, sexual harassment, theft, or other severe circumstances. It may also be possible that there's situations where progressive discipline isn't appropriate for management employees. Management employees are often held to a higher standard, and they're supposed to set the example for other employees in the organization. So it may possibly be easier to justify the termination of a management employee without having first resorted to progressive discipline. But with that being said, that will be the rare situation. So even with management employees, they should be informed of any performance issues or any allegations against them, and they should be provided the opportunity to improve or to respond to any allegations. And then lastly, progressive discipline may not be warranted where there's a zero tolerance policy in place. The zero tolerance policies are tricky. They're most commonly implemented in safety-sensitive workplaces and in a situation where they prohibit the use of drugs or alcohol in the workplace. You have to be careful with zero tolerance policies because they may inadvertently discriminate employees who require accommodation, or there may be situations where discipline is not appropriate in the circumstances. So in the next few slides, I'm just going to review situations where termination for cause may be warranted without having to resort to progressive discipline. So it's often said that termination for cause is the capital punishment of employment law, and it's going to be warranted in exceptional situations. You will usually only be warranted where the conduct on the part of the employee is incompatible with his or her duties, and it's conduct which goes to the root of the contract, with the result that the employment relationship is too fractured to expect the employer to provide a second chance. So essentially, trust is fundamentally broken and cannot be repaired between the two parties. And in the next few slides, I'm going to review some recent examples of situations where an adjudicator has held that termination for cause was warranted and that the employer didn't need to resort to progressive discipline before terminating these employees. So the first case is a case out of British Columbia from 2018, and it involves a person who was employed at WorkSafe BC. So it was a management at WorkSafe BC. She had been there for 36 years. And WorkSafe BC handles personal injury claims. So they handle very sensitive matters, including claims by their own employees. So this employee was a client services manager. She had a responsibility for claims made by employees of WorkSafe BC. And she was also an ethics advisor at WorkSafe BC, which meant that she was a resource for other employees on all matters relating to ethical conduct and the employer's standards of conduct. She was terminated for breaching confidentiality standards, and specifically, other employees made allegations that she was sharing confidential information with subordinates, which included the details of other employees' terminations before those employees were actually terminated, discussing information regarding the claims of other employees, and also disclosing to other employees that a staff at WorkSafe BC had threatened to report the handling of his claim to Global TV. The employer investigated. In the first investigation meeting, the manager denied all of the allegations against her. But throughout the course of the investigation, the allegations were corroborated by other employees. The employer then brought the manager in for a second investigation interview. She admitted that she may have possibly disclosed the possibility of a claim being reported to Global TV, but she denied all other allegations against her. So WorkSafe BC ultimately terminated her for cause. She brought a wrongful dismissal claim, and the court considered whether there was just cause for termination. At the hearing, the employee argued that even if she didn't admit that she committed these breaches of confidentiality, but even if she had, it wasn't so serious as to warrant just cause. She also argued that she had no history of discipline, she had 36 years of service, and there was no proof of actual harm stemming from any disclosure. So the court actually sided with WorkSafe BC. So it said that the employer did have just cause in these circumstances, and the factors that led the court to that decision were the important role of confidentiality at this particular organization. It was clear, as this employee was the ethics advisor, that she was aware of the standards of confidentiality and they had clearly been communicated to her. And she also knew that a breach of confidentiality could lead to termination. The court did acknowledge that one incident of a breach of confidentiality may not have warranted termination, but in this circumstance, there was multiple breaches and cumulatively together, they warranted just cause. The fact that the manager was not forthcoming in the investigation meetings troubled the court. And the court said that the relationship between the employer and the manager was simply too broken to repair. So the next case is actually a recent and very good example of the increasing severity with which employers are treating racially motivated conduct. And it really highlights the fact that times have changed and that incidents of racially motivated behavior by one employee against another are no longer considered quote unquote shop talk, particularly in the unionized workplaces. And it highlights that a single incident of racially motivated behavior could potentially justify termination for cause. So in this situation, it was two unionized employees and a verbal altercation broke out on the floor of the distribution center. A white employee aggressively directed racial slurs towards his Black coworker for approximately 10 minutes. The incident was actually witnessed by other employees, including racially and ethnically diverse employees. The company again conducted an investigation. And following the investigation, the company concluded that the employee's conduct violated company policies. And in particular, it violated the workplace harassment policy, which expressly prohibited all forms of racial and ethnic harassment, which included slurs, jokes, or inappropriate comments about a person's racial or ethnic background. And so this employee was ultimately terminated for cause. The union filed a grievance, and the union argued that the collective agreement requires just cause. They argued that this conduct amounted to quote unquote shop talk rather than egregious harassment, and that it wasn't just cause in the circumstances. The arbitrator disagreed with the union and it upheld the termination. The arbitrator specifically referenced evolving social and political views and the push to eliminate workplace harassment. And he held that it was appropriate to regard any use of demeaning ethnic or racial slurs by one employee to another as very serious misconduct, falling within the category of offenses that could potentially justify termination. And part of the reasons why termination was warranted in this situation was that the incident was overheard by other employees. And the arbitrator said if this behavior wasn't appropriately redressed, it could contribute to a poisoned work environment. And it could also lead other employees to the impression that minority groups or racialized groups in the workplace were treated less than equal. The employee also denied his wrongdoing. He didn't apologize during the arbitration. He didn't apologize in the investigation meetings, and he didn't demonstrate any genuine remorse for his conduct. And notwithstanding that this employee had 23 years of service and a clean disciplinary record, his termination was upheld. And so this next case is very appropriate in this circumstances. It actually deals with termination for cause of an employee who failed to follow both the employer's and public health guidelines related to COVID-19. And this is going to be workplace dependent because the severity of an employee's conduct in relation to not following COVID-19 measures will very much depend on the workplace at hand. But this is a situation of a security screener at Pearson International Airport. So the busiest airport in Canada, this person has very close and regular contact with not only her coworkers, but the traveling public. So all employees at Pearson Airport were informed that they had a requirement to self-isolate whenever they had a COVID-19 test and were awaiting test results. This employee was tested for COVID-19 on April 6, 2020. And notwithstanding that she was tested, she reported to work that very same day, contrary to both the employer's policy and public health guidelines. But then after April 6, she stayed home for the following 2 days. And 6 days later, after April 6, after her shift on April 6, the employee tests positive for COVID-19 or is informed that she had tested positive for COVID-19. She informs her employer. The employer then starts an investigation. And during the investigation, the employee lied and said she didn't work on April 6, 2020, which it's a bit odd considering the employer can very easily check that fact. But the employer checked and she did in fact work on April 6. But in a second investigation interview, she admitted that she worked on April 6th, but she alleged that she wasn't aware of the requirement to self-isolate while awaiting test results. And then she also said that the reason why she attended work on April 6th is because she didn't physically feel ill. She didn't feel any symptoms. There was nothing to indicate that she was sick. Andrew, you can go to the next slide. The employer in this situation terminated for cause. And her termination was actually upheld by the arbitrator. So the arbitrator concluded that it was very clear in this situation that all employees were informed of the requirement to self-isolate while waiting for test results. And that not only had the employer given this recommendation, or not this recommendation, this requirement, but that it was also a guideline of Public Health Canada. And the arbitrator also, he just looked at the facts of the situation. He said that in April 2020, there was wall-to-wall coverage of COVID-19. So this wasn't a situation where the employee would have no knowledge of COVID-19. She worked at an airport. This was clearly something that was top of mind for her employer. The arbitrator found that the guidance from the Public Health Agency of Canada was very well known at the time to the general public. And as a result, he determined that the griever's actions not only violated workplace policies, but also public health guidelines. And he said that the fact that the griever didn't feel any symptoms on April 6th was totally irrelevant. She put not only her coworkers at risk, but also members of the general public. So you can go to the next slide, Andrea. So this slide is really just to highlight that building a clear case of just cause is really, really important in the unionized context. So unlike the non-unionized context, an employer doesn't have the ability to terminate a unionized employee for anything but cause, other than in situations where there's perhaps a lack of work. So properly implementing discipline and keeping a clear documentary record can be critical for making out a case for just cause in the unionized setting. And I think we all know that courts, arbitrators, adjudicators are very, very hesitant to find that an employer has just cause, particularly in situations where we're talking about a single incident. It's going to be a very, very rare situation where an employer will be able to justify a for-cause termination without a good investigation and supporting documents. And as I said before, documents and the investigation can make or break a case. And Matt talked about this previously, but the employer does bear the onus of establishing that it had cause to terminate. And it's a very high legal threshold. So you have to show that on the balance of probabilities, the employee's conduct fundamentally damaged the trust between the employer and the employee. And it's a bit of a balancing act. Often an employer will want to get rid of an employee after a number of incidents of poor performance or inappropriate conduct, but as frustrating as it may be, the documentary trail or the evidence you have may not be enough to justify termination for cause. And it may take some time to build a case. So we've seen many situations where performance is bad, but it's just not bad enough to meet that threshold. And in those situations, it may be risky to terminate for cause, given that it's very likely that the employee will either bring a wrongful dismissal claim or a grievance in the unionized setting. This could lead to significant legal fees. If the employee is successful in the litigation, it could lead to costs against the employer. It could also potentially lead to aggravated or punitive damages if the court or the adjudicator finds that cause was not warranted and that the employer should not have maintained their position that it was. And then it can also, in the unionized setting, lead to reinstatement of the employee. And then so Matt's going to be upset because this is Matt's favorite slide. So this slide really just goes over the importance of a proper investigation. So the billboard, the famous billboard that says, just because you did it doesn't mean you're guilty. And in all of the cases that I previously reviewed, the employer conducted a thorough and good investigation. Without an investigation, without any evidence or documents to support your position, you probably don't stand a chance. You won't be able to prove that just cause was warranted. And then at the other end of the spectrum, so there may be situations, smaller offenses where progressive discipline may not be warranted right off the bat. Repeat offenses, if there's repeat offenses, it may ultimately lead to progressive discipline, but there can be situations where an employer can be a bit more flexible to nip an issue in the bud. So particularly in workplaces where there's a bit more flexible work standards and where the employer has some more flexibility to deal with employees. So examples of this could be a few absences, some issues of punctuality, including arriving late or leaving early, someone taking extended lunch breaks, or long smoking breaks or really long breaks throughout the day. In these situations, the starting point might simply be to have an honest conversation with the employee, to ask them if there's a problem that the employer could be supportive with or flexible with. There could be some easily implemented solutions that will immediately correct the problem. So implementing flexible work hours or allowing them to make up the time on other days if they have some commitments on certain days. And this conversation may lead the employer to learn that some form of accommodation may be necessary. There may be some human rights considerations. But if it gets to the situation where coaching or talking to the employee doesn't ultimately improve the behavior, progressive discipline may then be appropriate. And I will turn it over to Matt to talk about performance management and performance improvement plans.
Great. Thanks, Gillian. And thank you for including my favorite legal billboard. Just because you did it doesn't mean you're guilty. It's an oldie but a goodie. The importance of performance management, I think, it really cannot be understated. If ultimately you're looking to try and correct behavior, or ultimately form the basis of discipline that moves forward through potentially a termination of employment. I mean, no doubt about it. It's one of the most common and difficult issues facing employers. No one wants to give bad news. No one wants to feel that their performance is substandard and that they need to have someone looking over their shoulder. It can have a negative impact on productivity. Certainly, the person in charge of the performance management, that results in more work for you. But ultimately, it's critically important as an employer to implement and follow a consistent performance management system. And that can apply to any number of performance issues, things like the employee's work output, their quality or the quantity. They may be consistently behind schedule. They may be unable to maintain satisfactory or productive relationships with their coworkers. They may be absent, late, on time. All of these issues are ripe for proper, consistent, and effective performance management. And again, as an employer, I think it's important to, because we sometimes sort of forget at the end of the day that employers have a right to expect a certain level of performance from their employees, particularly in the non-unionized setting. And so what you're able to do as part of your performance management program is to, first of all, establish reasonable production standards, expect that employees will perform their assigned duties in a careful and conscientious manner, expect that employees will generally exhibit a positive attitude and work habits. And then ultimately, as the employer, you have a right to impose discipline when employees fail to meet standards of performance because of culpable conduct. And it's important to draw a distinction there between culpable and non-culpable conduct or performance. Culpable poor performance, for example, is the inability to fulfill requirements because of factors within the control of the employee. So inattentiveness, carelessness, poor attitude, disregard of procedures. Non-culpable poor performance is the inability to fulfill requirements because of factors beyond the employee's control. So, for example, beyond their capabilities and abilities because of, for example, a mental or physical disability of some kind. An employer generally can't discipline an employee for poor performance if it's the result of non-culpable behavior on the part of the employee. And in fact, in some instances, if the issue relates to, for example, a disability, there may in fact be a duty to accommodate the employee under human rights legislation. To terminate for poor performance, again, it has to be, generally has to be serious and willful, often sort of rising to the gross or serious misconduct standard. Next slide, please. Again, talked about in terms of assessing performance, it's important that certainly in the unionized setting and even in the non-unionized workplace, the employer cannot insist on perfection in every respect of every duty that's been assigned. Employees will make mistakes from time to time. The test for assessing qualifications and capabilities is one of reasonableness. Next slide, please. We touched on this earlier, and I think probably both Gillian and Alex did as well, is that the overall goal in managing performance should be in order to have the employee improve their performance, not to discipline up to and including termination. Effective performance management, no doubt, means that you're going to have to rely on your frontline managers and supervisors with senior management and human resources providing support and communicating performance issues, expectations for improvement is key. Leaving it unspoken or unclear is not going to be of assistance. Next slide, please. And then before I turn it over to Gillian, just want to quickly talk about performance feedback and reviews. You do not want to wait until the semi-annual or annual performance review to raise issues with employees. You want to be able to do it at the time they happen. However, if you haven't, or as a means of reinforcing it, it's important to take advantage of the formal performance review process to be specific, frank, thorough in providing constructive feedback as to ways that the individual can improve. And just a quick story of a case that I had a number of years ago where the failure to be honest, thorough, and frank in the performance review caused a real problem for the employer. Had a case where the company was undergoing a restructuring and had to terminate 1 out of 3 employees on a without cause basis, just because there was only going to be work remaining for 2 of the employees. And the individual they chose, although it was a without cause termination, the stated basis that the manager provided was that this person allegedly had poor attendance issues. They arrived late, they left early, all those sorts of things. He was terminated on a without cause basis, filed a claim for wrongful dismissal, and in that claim alleged that in fact that the termination was based on human rights related grounds, raised age, disability, a number of other factors. And so when we were preparing our statement of defense, I asked the client, okay, well, can we see these performance reviews which talk about what a poor performer this employee was? And it turns out that in each of the 3 years prior to termination, all 3 employees on all 3 years performance reviews received meets expectations review scores. And there was nothing in there about any of the issues that the manager allegedly raised as picking this employee over others. So you can imagine the difficulty that caused us in terms of defending that claim. Gillian?
So there are a number of different ways that an employer can manage employee performance, and termination is not the only option. So depending on the situation, performance management options could include placing an employee on a performance improvement plan, which we'll talk about momentarily, implementing progressive discipline, as we've already discussed. And there may be situations where a demotion could be appropriate. So it's more than possible an employee could be a strong performer in a different role and that they've simply been given work above their pay grade or work that requires more skill or knowledge than they currently have. But we should qualify that by saying that demotions are risky. If an employer does really alter the employee's job duties or significantly changes their compensation package, the employee can argue that they've been constructively dismissed. As we discussed previously, there may be situations where termination for cause is warranted, either following progressive discipline or due to a single severe incident. And then in non-unionized settings, an employer can decide that it's simply not worth the time or energy required to bring an employee's performance in line with expected standards. In that situation, it may be appropriate for the employer to terminate without cause and offer the employee a severance package. And next, we will turn to performance improvement plans. So as Matt said previously, the goal is to improve performance. It's not purely to discipline employees or to create a documentary record. You truly do want an employee to improve their performance. So poor performance shouldn't be ignored or condoned for a long period of time. And an appropriate way to manage poor performance may be through a performance improvement plan. And a performance improvement plan is really intended to put an employee on notice that their job performance is not meeting standards or expectations and that it requires improvement. They're generally implemented once an employee has been informed of issues with performance on one or more occasions. And it lets the employee know that if they don't show sustained improvement over a reasonable period of time, they could be subject to discipline up to and including termination. It's important that a performance improvement plan be fair. So the employee actually needs to be advised of these specific areas of performance that require improvement. And they should also be told the objectives that they need to meet in order to improve their performance. So they should be given specific tasks with specific deadlines. And then there should be a period for completion of meeting the required performance objectives. And throughout the monitoring period, the employee shouldn't just be left to their own devices to meet these expectations and standards. There should be regular follow-up with the employee to see how it's going, to ensure that any appropriate supports or training is being provided, and to actually give them an opportunity to meet the performance objectives. In the next slide, we've just provided an example of a performance improvement plan here. So as you'll see, it clearly specifies the time period of the performance improvement plan. It lets the employee know the specific areas of concerns and the expectations going forward, and it gives them a period of time to meet those expectations. And a few things to avoid when implementing a performance improvement plan include setting unrealistic expectations. So the employee shouldn't be provided with these new expectations that weren't part of their job duties previously. It should be job expectations that they can realistically meet within the timeframes provided. You shouldn't be increasing performance targets, so they should be meeting the performance targets expected of the position at the time the performance improvement plan was implemented. You shouldn't be making it harder for an employee to meet expectations. And then you likely shouldn't discuss any further progressive discipline or any future steps in terms of discipline until the employee has actually been provided with the opportunity to improve their performance and the full period of the evaluation for the performance improvement plan is complete. I'll very briefly communicate a case where the Ontario Court of Appeal said no, like this performance improvement plan was not valid. So this was a situation of an employee who worked as a store manager at a McDonald's franchise. The employee was a 20-year employee. Every year, she consistently received performance or positive performance reviews. And then one year, in one performance review, it was a negative one. It came as a shock to her, as I said, 20 years of positive performance reviews. And rather than place this employee on a performance improvement plan at her own store, her own franchise, the employer actually transferred her to a poorly performing restaurant and increased her performance standards or increased her targets that she had to meet. And the employer gave her a period of 90 days to meet those increased targets. Ultimately, she didn't meet those targets and she was terminated, or she was actually demoted to the first assistant position. And then she did not agree to take that position and was then terminated for cause. She brought a constructive dismissal claim. The court said, no, this was a wrongful dismissal. I'm sorry, but your performance improvement plan was arbitrary and it wasn't realistic. She was moved to a failing store and given increased targets. This was not a reasonable performance improvement plan in the circumstances. The judge found that while the manager was not perfect, she was competent and she had a long track record of success, and that the failure to meet performance standards was not cause for dismissal in the circumstances. So that's just an example of a situation where performance improvement plans, if implemented, must be reasonable and they must actually be attainable in the circumstances.
Before we'd open up for questions, there are a couple of special circumstances involving reprisal and human rights in discipline that we'd like to review with you. With respect to human rights, it's very important that before taking any steps to discipline or terminate an employee, that the employer first consider whether the employee's actions are caused by a disability. This is especially important in circumstances where the employer is aware or perceives that the employee has a disability that is affecting their conduct or their performance in the workplace. If disability is a factor, then discipline is not the appropriate response and accommodation is required under human rights legislation. Discipline is generally reserved for cases of culpable or careless conduct rather than conduct that is beyond an employee's ability or capacity to control or to choose. So that may be the case in many instances of disability, such as mental health disabilities, which are not only prevalent right now in society and in the workplace, but also not always visible to others in the workplace. Generally, accommodation starts with a request from the employee coming forward with a disability and a request for accommodation. However, courts and human rights tribunals are increasingly recognizing that in some circumstances, employers may also have a duty to inquire in some cases to determine whether an employee does require accommodation. For example, a duty to inquire may arise where an employee's poor performance is noticed and there's a marked change from good performance to bad performance, or where an employee's attendance at work suddenly starts suffering. In those circumstances, it may be reasonable to inquire about non-culpable reasons for why that is occurring and to explore opportunities for accommodation or collaborative improvement in performance. A duty to inquire does not necessarily mean the right to know what the diagnosis is. That's generally confidential medical information. But in many cases, what human rights legislation and the accommodation process does require is an understanding of the nature of the disability, the restrictions and limitations that it presents, and how those factor in to the employee's performance. Even then, it's not always easy, particularly in cases of mental illness or disability, to establish whether the disability caused the poor performance or the misconduct. It does not need to be the cause, though. It's important to note that the disability only needs to be a factor in the adverse treatment or discipline in order for discrimination to be established. So with that in mind, prudent employers should offer to help and support employees before imposing severe sanctions, and also consider that some mental illnesses may make employees incapable of identifying their needs and requesting accommodation. Some employees who do have disabilities may not self-identify as persons with disabilities. An interesting example of where this comes up sometimes is with substance use and addiction in the workplace. It's been recognized as a disability where denial and relapse are inherent in the disability, which not only makes it harder for employees to disclose and seek accommodation, but also to consistently follow the required standards of performance, even with accommodation. What the duty to accommodate says is that this is not a culpable basis for discipline, but it may still result in termination provided that accommodations are not able to address or improve the conduct short of undue hardship. Poisoned workplace is also relevant to progressive discipline, because a poisoned workplace is typically what happens when there are a number of incidents of misconduct, often involving discriminatory or harassing behavior, that accumulate and have not been appropriately dealt with. Dealing with misconduct as it arises on a case-by-case basis can prevent a poisoned workplace, and is often a much more efficient and effective way of dealing with issues, rather than waiting until it's too late. And when there's a poisoned workplace, which often is indicated by low morale, turnover, absenteeism, and requires much more drastic solutions at that point to change the culture. Next slide, please. Reprisal is another related concept. Reprisal is when discipline is imposed for reasons relating to an employee's attempt to enforce their rights under certain legislation, such as the Human Rights Code or the Occupational Health and Safety Act. These pieces of legislation say that employees cannot be penalized for trying to assert their rights, for example, to insist on a healthy and safe workplace. It doesn't mean that employees cannot be disciplined. It just means that the employer has to prove, often there is an onus of proof on the employer to prove that the exercise of statutory rights was not a factor in the decision. This can be difficult because often the misconduct at issue will have some kind of nexus, at least factually, in the chronology with the exercise of rights. So often one way of addressing this is to increase the time between, to create distance between the two issues, and to treat them separately rather than proceeding with discipline in circumstances where, say, an employee has just taken a leave of absence, or where an employee has just raised an allegation of discrimination. Next slide, please.
All right. Thanks very much, everyone. So we have just a few minutes left, and I have to say that we got some really great questions, both in advance of today's session and also ones that have come in now. I've been monitoring them. Maybe I'll just take a couple of them here and then ask both Gillian and Alex to weigh in on questions separately. So real quickly here, first of all, does a written notice need to be signed by the employee? This is a good question. The answer is generally no. Certainly in the non-unionized context, particularly if you're meeting with the employee, issuing them the notice, it is what it is. In the unionized context, you sometimes find situations where the employee refuses to sign. So there's an acknowledgement section. The employee refuses to sign, and they somehow think that will mean that it's not valid. One way to deal with that is to have the supervisor who's issuing the notice simply write in, employee refused to sign. And in most cases, in the unionized setting, because a union representative has to be present, you're going to have that person there. So if there was ever a dispute as to whether the letter was issued, there's going to be someone else present. On the subject of union representation, the question here is union representation mandatory if the employee defers? This is another good question. It's a tricky one. I think my answer to this is, at the end of the day, in the unionized environment, it is the union that's the bargaining agent that represents employees, but that has carriage of grievances. And so even if you have a situation where an employee says, I don't need to have a union steward present, I don't need to have a union steward present, if the collective agreement provides they have to have union representation present, I would wait until there is a union representative available to meet with the employee, because the employee can always change their story afterwards. And what you're faced with is the express language of the collective agreement, which requires union representation. Let's see, maybe one for Gillian. About how long is a disciplinary notice or measure valid? And how much time can pass between various disciplinary notices in order to still be valid? What do you think about that?
So, as with many answers, I think it's going to depend on the situation. If it is a unionized environment, the collective agreement very likely specifies how long discipline is valid for. So as Matt said at the beginning of the presentation, most collective agreements will contain what's called a sunset clause, and it usually provides that discipline is wiped off of the employee's record or off the employee file after a period of, it will specify, but usually it's a period of 18 months or 2 years. In the non-unionized setting, there is no hard and fast rule. There's no reason why discipline can't remain on an employee's file for a significant period of time. And maintaining that record of discipline and past discipline just really helps support a further termination or further discipline down the line. So again, the non-unionized setting, unless there's a policy that specifically states how long discipline is valid for, there's really no hard and fast rule. And I would say to just keep it in the employee file for as long as reasonably possible or necessary.
Sounds good. Sounds good. And Alex, but if you want to take this one, actually this one is timely given COVID and the challenges going on right now. How should employers manage progressive discipline in situations where it's known that there are mental health challenges, but the employee's substandard performance is putting pressure on the rest of the team?
I think that's a common issue these days with COVID. It's important to recognize in that question that there's already an implicit recognition of a potential mental health or disability issue in the background. So that seems like an appropriate case where a duty to inquire or a duty to pursue non-disciplinary measures would be the most appropriate response to see what accommodation can improve the situation short of resorting to disciplinary penalties. But it also is important to understand that there may or there may not be a nexus between the conduct and a disability. So certainly moving forward with an inquiry with that employee and a conversation will help understand the situation better and how it can be addressed. Great,
excellent. Oh, I think that's absolutely right. Okay, well, we are 3 minutes over time. I want to thank everyone virtually online for their attendance and for all the terrific questions that we received, for Gillian and Alex and the IT team for helping put this presentation together and help it run smoothly. And thank you again for your attendance today, and wish you a safe and pleasant afternoon.